there's another question before we run out of time. There's another question here from online. This is a person who says, if I'm working for a company and signed a non-compete agreement for up to 12 months, what is considered competition? For example, if I worked at Google on their search engine and I wanted to go to RIM to work on their phones, would that fall under the non-compete agreement? The two companies compete, but I would be working on very different domain. And what about if I'm a contractor at one company and want to head to a competitor, but again, for a very different role, working with different technologies? How would a non-compete apply in these situations?
All right. The best way to answer this is that the employer who drafted the non-compete has the obligation in drafting that language to set out what they view as a competition, because it may not be entirely clear just from looking at the circumstance. And the point of drafting and having an enforceable non-competition agreement is to make sure that the people who are bound by it know what is unfair competition or not. So in this case, it looks like the employer who drafted the clause didn't do a very good job of outlining who the competitors are or what the competitive type of work is. So it's often a good idea in a non-competition agreement, if you're looking at this from the employer's perspective, to specifically say, here is a list of companies. It's not exhaustive, but here is the list of companies that we consider are competitive to what we do, and you shouldn't be working for them for the 12-month period of time after you leave. Then at least the individual who signed that clause knows what the employer feels is a competitor. Because if it's not clear, if it's vague, or if it's ambiguous, it makes it more difficult for the employer to enforce that agreement. The employee basically has an out, and the out is I didn't know where I went to work was a competitor, or I'm doing work for that company that isn't competitive in nature to what I did with the company that I left. And you have to look at the exact language of the non-compete. So those things really, really need to be drafted with a high degree of with precision to make sure you get it right, because any ambiguity is going to be held against the employer and is to the employee's benefit.
Right. So if your non-compete clause says, okay, you work, let's say, okay, you work at Google, you cannot work with any of our competitors, end of story, and there's nothing specific about it. As an employee, can you just say, well, here's my case? Do you have to talk to the HR there and do it, or do you just wait to see whether they might try to sue you? Because then you end up in some real different...
Well, okay, so you really want to meet with a lawyer about that, because the advice I give to people is different depending on circumstances. Sometimes I'll tell people, I'll say, look, it's not clear. It seems to me like where you're going to work really isn't contrary to the intention, the pith and substance of this non-compete, and you should go to the company that you left and ask them what their position is if you were to take a job with XYZ Corp. And sometimes they'll come back and say, we don't have a problem with that, and sometimes they'll come back and say, we do have a problem with that, and if you work there, we're going to sue you. Well, then at least you know, okay? So, and it's better to know than to go there and wind up with a lawsuit on your desk on the first day.
Right.
Sometimes I'll look at the way the contract is drafted, and I'll tell the employee, I really don't think that the employer is going to be able to hold this contract up in court and have a judge say, I think it's enforceable. So someone's going to have to take the risk that if they are sued in that case, that it's not going to go very far, because the way the contract is drafted. And don't forget, it's the employer's onus to draft that contract properly, and it's also the employer's onus to enforce it too. So it's really, really fact specific, Jillian, and you basically have to start with, how is the contract drafted? What does it say? If it says there's a 12-month restriction on competing anywhere in the world, that's a lot different than saying, I'm from Toronto and I worked at Google, as your example, in Toronto, and I'm not going to be able to walk across the street and work for Google's main competitor, which is in Toronto. It's a lot different than saying I can't go work anywhere in the world. So it really, really depends on how these clauses are drafted. What's the temporal limit? How long is it lasting for? What's the geographical limit? And what's the radius of the non-compete? I mean, there are so many different ways to argue that it's not enforceable. For the most part, employees are protected when they want to go work somewhere else, unless there's a very clear case that they shouldn't.
Mm-hmm. Now, when it comes, if you're a little bit more of the down the rung on the leadership ladder, that you're not that high up, where a CEO, that's a different story, or your top manager or something like that. do courts look at it that if you have put in non-compete clauses for absolutely everyone in your company, including the most entry positions, do they look on that a bit poorly, that you're basically trying to prevent someone from taking their experience and continuing to work?
Yeah, for sure. I mean, the non-competes are prima facie. What prima facie means, the first time you look at them, they're unenforceable in the court's eyes unless the employer can prove it's enforceable for some reason. So it's like a reverse onus. Okay, basically, you start from the proposition that you are not guilty unless the employer can prove you are, and that's a high onus to meet. So if you are a lower level employee, it's an even higher onus to meet. And the first thing an employer has to do is to establish that a non-compete is even needed. In some cases, there is no need for a non-compete because there's nothing to protect. A non-solicitation may do that job just as good, if not better, and the courts have basically directed employers to try to restrict people's ability to compete with them through non-solicitation clauses.
Non-solicitation. What's that? Yeah.
So a non-compete says that after you leave working for my law firm, you're not going to go walk across the street and work for my competitor for a certain period of time. A non-solicit says after you leave working for my law firm for whatever reason, you're not going to go to one of my competitors and call my clients and tell them to come work with you. Okay? So in the second scenario, you can go work wherever you want. You can make a living. You can make use of your knowledge in the industry. You can have touch with be in touch with your contacts, but you're simply not going to call my clients that you serviced while you worked for me and say, I'm going to do a better job for you over here than I was when I was with Lublin. So get rid of that guy, and I'll give you a better deal. Come over here. That's a non-solicit. Is if you put it in places, you won't call these people and solicit them to come work for you, and the courts will respect that in considerably more cases than they would a non-compete.
Right. I've also heard of a couple situations where someone has moved to another company. They've shown them the non-compete from their former employer, and the new company has said, well, we'll defend you and we'll fight against you if anything happens because we want you with us. And we don't think this applies.
Music to my ears, Jillian, okay? Because that basically gives the employee who went to the new company, it gives them a sense of comfort that they're protected if there is going to be an issue. And if you're the employer that wants to sue someone on non-compete, you'd much prefer suing the little old individual than going after the company that he's working for, because then you know that he's got protection and he's got some deep pockets that's going to defend him. So I tell people, and this is really good advice for people that they need to remember, is if you know you're subject to some form of a post-employment restriction, number one is make sure you show it to the company you're going to work for if you think that it may be a conflict with that clause, okay? And put it on their shoulders to, number one, assess and make sure that they agree with you that ultimately it wouldn't stand up in court, or the employer that you left isn't going to chase you for it. And number two is you may want to negotiate, and obviously this is easier to do for people who are recruited or who are in senior positions and have some negotiating leverage. Try to negotiate some form of an indemnity, which is basically the employer that's hiring you saying, we'll pick up the costs of fighting this if it's going to be fought, because we'd rather have you working here than not. And that's the best form of protection you can get.
All right. Very good. All right. We have maybe time for one more question here. Let's see if this one's answerable in a few minutes. Okay, this one's, I think we're on to Severance again. This is a real estate company that sold all of its buildings, commercial industrial buildings, and operating platform to another company. A lot of the employees are expecting to receive offers from the new company, and some will get severance from the current employer. And this person asks, do I have to accept the new offer if it is similar to the compensation that we're expected to get? Is it possible to try and seek a package from the current owner if I don't want to go to that new company? This person has 7 years of service, and one of the reasons they stayed with the current company is because of its name and profile.
So this is an ongoing dispute at my firm. I'm having an argument with one of the lawyers that works for me over this very situation. And basically, if the reoffer of employment is comparable in all respects, it would be highly problematic from the law's perspective to reject that and pursue a severance against the company that let you go. So if you are being offered employment from a purchaser, and the reemployment offer is basically the same as the job you had, So there's nothing prejudicial in that contract offer, and you're not losing any pay or status or tenure or anything like that. You generally can't reject that, because if you do, you're going to be seen as failing to mitigate, and you can't go after the company that fired you or sold you and say you owe me a year's severance when you could have worked in the same position, frankly at the same desk, doing the same work for the same money, for the money you would have got over that 12-month period. So you basically have an obligation to take it. The issue is when the reemployment offer is a comparable. Does it have that clause in it about termination, the one that I was talking about earlier? Does it say that we can change your position without notice? Does it say that we can move your job, to our plant that's a 3-hour drive from your home? So you have to look at whether or not the reemployment offer is comparable in all respects. And if it's anywhere close to the job that you had, it's problematic, in my view, to reject the offer of employment and sue the company that sold you for severance, or the company that bought the company that sold you for severance, because they've got a great defense sitting there which says you could have worked here and made the money back that you're suing us for.
Right. All right, well, I think that's all the questions we have time for today. Thanks for joining us. This was great. I'm sure we answered a good number of emails, and a few people got questions in today as well, so I hope they are watching and got to hear your answers. And we'll look forward to doing another one of these soon. I'm sure we'll get a lot more mail.
Excellent. Thanks so much for having me. I can be reached through my website is www.toronto-employmentlawyer.com. Thank you.
All right. Thanks so much.